Good day, everyone. In this video, I will be discussing and reflecting on the Supreme Court case of Christian Cadaas y Cabias versus People of the Philippines, docketed as GR number 247348. This is a criminal case involving child pornography committed through digital means, specifically through Facebook Messenger. This case is important because it tackles several major legal concepts that are highly relevant in today's digital age. It discusses online privacy, the limits of constitutional protection, consent involving minors, cybercrime penalties, and the state's role in protecting children. More importantly, it shows how the law treats acts that may be brushed off by some as online jokes or private exchanges, but are in fact very serious crimes with severe consequences. In this reflection, I will explain what the case is all about, go through all the facts in detail, discuss the issues raised, explain the Supreme Court's ruling, and share my thoughts and key learnings from the case. So, what is the case all about? The case revolves around the conviction of Christian Cadaas for child pornography under the Republic Act 9775, also known as Anti-Child Pornography Act of 2009, in relation to Republic Act 10175, the Cybercrime Protection Act. The court issue is that Christian, who was 24 years old at the time, induced a 14-year-old minor, referred to as simply for short AAA, to send him nude photographs of her breasts and vagina through Facebook Messenger. These images were later discovered by the child's mother, BBB, who then used them as evidence to file a criminal case against him. Beyond the act itself, this case also raises constitutional questions. Christian argued that the evidence used against him violated his right to privacy because the Facebook messages and photos were accessed without his consent. He claimed that these were private communications and that the evidence should be excluded as fruits of an illegal search. The case therefore goes beyond a simple criminal investigation. It clarifies whether constitutional protections on privacy apply when evidence is obtained by a private individual, not the state. It also answers whether a so-called romantic relationship or alleged consent by a minor can excuse criminal liability in cases involving child pornography. Ultimately, the case sends a strong message about how the law views digital grooming, online sexual exploitation of minors, and mainly the misuse of social media platforms nowadays. So what are the facts of the case? The facts of the case show a gradual pattern of manipulation and abuse. Christian was only 24 years old when he met AAA, who was only 14 years old at the time. They met at a canteen and eventually developed a relationship. In April 2016, they became what they described as sweethearts. Despite the large age gap and the minor status of AAA, Christian continued communicating with her through Facebook Messenger. And at some point, AAA's mother, BBB, discovered their relationship. She found messages between Christian and her daughter after AAA accidentally left her Facebook account logged in. Alarmed by what she saw, BBB confronted Christian and warned him to stay away from AAA because her daughter was still a minor. But despite this warning, Christian did not stop communicating with AAA. On November 18, 2016, BBB checked again AAA's Messenger account and discovered a disturbing conversation. In these messages, Christian repeatedly coaxed and pressured AAA to send nude photos of her private parts. And at first, AAA refused, but after the persistent urging, She eventually gave in and sent photos of her breasts and vagina to Christian. Upon discovering this, though, BBB confronted AAA and demanded access to Christian's Facebook account. AAA revealed that Christian had previously given her his Facebook password. Using the password, BBB accessed Christian's Messenger account and retrieved copies of the conversation and the photos. And these materials were later turned over to the authorities and used as evidence. Now, Christian was charged with 2 offenses. The first was a violation of Section 10A of Republic Act number 7610, or child abuse. And the second was child pornography under RA 9775, committed through information and communications technology, which also brought the case under the RA 10175. The regional trial court acquitted Christian of child abuse but found him guilty of child pornography. He was initially sentenced to reclusion temporal, but the Court of Appeals affirmed the conviction, prompting Christian to elevate the case to the Supreme Court. Now, what are the issues in this case? Several key legal issues were raised in this case. First is the admissibility of evidence. Christian argued that the Facebook messages and nude photos should not have been admitted because they were obtained without his consent. He also claimed that his constitutional right to privacy and the evidence should be excluded as fruits of the poisonous tree. Second is the issue of consent and sweetheart defense. Christian claimed that the AAA voluntarily sent the photos and that they were in a romantic relationship. He argued that there was no force or coercion and that the messages were sent as a joke or out of affection. Third is the nature of the crime. The issue was whether a minor to send nude photos already constitutes child pornography, even if there was no intent to sell, publish, or distribute the images. Fourth is the classification of the offense. The court needed to determine whether child pornography is mala in se, meaning inherently evil, or malum prohibitum, meaning wrong only because it is prohibited by the law. Now, this distinction is very important and affects how intent is treated in criminal liability. So, what is the ruling of the Supreme Court? The Supreme Court denied Christian's petition and affirmed his conviction for child pornography. However, it modified the penalty and imposed a heavier sentence. On the issue of privacy, the court ruled that the evidence was admissible. The constitutional protection against unreasonable searches and seizures applies only against actions of the state and not private individuals. And in this case, the evidence was obtained by BBB, a private person acting as a concerned parent. Therefore, this exclusionary rule did not apply. The court also ruled that Christian had only a limited expectation of privacy. And by voluntarily giving AAA his Facebook password, he effectively allowed her access to his account. And since BBB accessed the messages through AAA, there was no legal intrusion protected by the Constitution. And on criminal liability, the court held that Christian committed the child pornography by inducing a minor to perform in the creation of pornographic material. Under RA 9775, inducement alone is sufficient, and there is no requirement that the offender personally took the photos or distributed them. The act of persistently coaxing a minor to produce sexual images already satisfies the elements of the crime. The Supreme Court firmly rejected the sweetheart case. It ruled that the consent is immaterial in child pornography cases, and a 14-year-old is legally incapable of giving valid consent to sexual exploitation. Any claim that the act was voluntary or done out of affection is irrelevant under the law. And regarding the classification of the offense, the court clarified that child pornography is a mala in se. It is inherently immoral and harmful. So in this case, criminal intent was clearly established by Christian's repeated pressure and manipulation of the victim. Finally, for the penalty, the court ruled that because the crime was committed under a computer system, Facebook Messenger in this case, the penalty must be 1 degree higher under RA 10175. As a result, the penalty was increased from reclusion temporal to reclusion perpetua, or life imprisonment, along with a fine of 1 million pesos. Now, this case offers several important lessons. First, privacy rights are not absolute, especially against private individuals. The Constitution protects citizens from abusive government action, not from the actions of private people acting on their own. Second, digital grooming is treated as a serious crime. The court recognized the power imbalance between an adult and a minor. Online platforms do not make exploitation less serious. In fact, the law treats online sexual exploitation as more dangerous because of the ease of repetition and dissemination. Third, the 1 degree higher rule under cybercrime laws significantly increases penalties. Acts done online carry heavier consequences than their offline equivalents. Fourth, consent from a minor has no legal value in child pornography cases. This is a crucial point. Even if a child appears willing, the law assumes incapacity to consent. The responsibility always falls on the adult. Fifth, the case reinforces the state's role as parens patriae. The government has a duty to protect children from the subtle, non-violent forms of abuse. And finally, this case serves as a strong warning. Online actions that some may dismiss as private messages or jokes can lead to life imprisonment. Technology does not shield offenders. Instead, it exposes them to harsher penalties. This is all from me. Thank you.